fill up the detailed list. Lordship may not like to take up this matter.
11, 12, list these matters before any other bench without one of us, bracket my name.
Deeply obliged. Lordship, I beg to mention item number 10 of the daily cause list. Lordship, the engaged counsel is out of station due to the Shraddha ceremony of his father. So, Lordship, matter
You are appearing for whom?
for the petitioner,
Acha, who's the engaged counsel?
M.K. Sharma.
It is submitted at the bar that the learned counsel for the petitioner in this case could not come to court today as he is engaged in the Shraddha ceremony of his father. Full stop. On such ground, a prayer has been made to adjourn this matter for 2 weeks. Full stop. The prayer is not opposed by learned counsel for the respondents. Full stop. As such, comma, the same stands allowed. Registry to list the matter accordingly.
Published.
Item number 1 of daily list for motion.
Lordship, item number 1, 2, 3, and 5, Lordship.
What are these? PI public interest?
Lordship, we are public interest litigation, Lordship. Lordship, all are more or less similar, Lordship. I have, in fact, sought some directions from this honorable court, Lordship, for against corruption, nepotism, financial irregularity, embezzlement of fund of Assam Agricultural University, Lordship. I have unearthed many things through RTI, Lordship, and with supportive documents, Lordship, which I have enclosed, rules, acts, everything I have enclosed, Lordship. And I seek that this should be, Lordship, I have already unearthed this. This should have the legal process, Lordship. By
What is the legal process?
legal process, Lordship, that means enforcement. Enforcement for some forces should be there to look into the irregularities that I have unearthed and take appropriate action, Lordship, as per permissible, Lordship.
No, but have you lodged any FIR?
Lordship, FIRs have been lodged, and Lordship, I have also filed a memorandum to the Chancellor of the university, that is the Governor of Assam, Lordship, Honorable Chancellor. And Lordship, those have not been met, Lordship. I have lodged FIR, written memorandum to the DGP.
Now, who are you?
To the
Who is
enforcement
the
director.
petitioner here? Who is the
Lordship,
petitioner?
petitioner is an RTI activist, Lordship. And Lordship, he has an organization, Lordship, well-known organization in Assam, Lordship. Lordship, that I have stated in each of the PI, Lordship, at paragraph 2, Lordship.
Where is the complaint in the first item, item 1?
Lordship.
Why so many petitions?
Lordship, I could not make it out in one petition, Lordship.
Why?
Lordship, voluminous, Lordship, I have given all the acts, Lordship, all the supporting documents, Lordship, and that would have covered, Lordship, more than 3,000 pages.
So
Lordship.
because the petition is big, so
Lordship,
you have turned it into several read petitions.
No, Lordship, similar matters I have given in one petition, Lordship. That means for embezzlement found one, for other corruptions, another, Lordship, for promotions and appointments, Lordship, another petition, and so on, Lordship. This, Lordship, transfer of land also is there, Lordship. Transfer of land to NGOs, Lordship, without following the proper procedures, Lordship.
Who has transferred land?
Lordship, the VC, Vice Chancellor, Lordship, without the knowledge of the Chancellor, Lordship, without the knowledge of other concerned persons, Lordship.
Yes, who is appearing?
I'm appearing for the university. Lordship, firstly, because this is the PIL, perhaps the scrutiny of the antecedents of the petitioner would be a little more intensive, Lordship. Firstly, Your Lordship, there is no doubt that he belongs to a political organization, pseudo-political organization, and he is admitted as such in the petition. Now, what we have to see is whether his public spiritedness, Your Lordship, stops at the gates of the Agriculture University, or does it extend to other organizations as well? Because in one single day, he has filed 4 petitions against the same institution. And though my learned friend is saying that he has only differentiated them because they would have been too voluminous, from the prayers, it appears, Your Lordship, the prayers are also separate in all the 4. And the 4, in fact, can be classified, Your Lordship, into 4 distinct kinds of petitions. In item numbers 1 and 2, the petitioner is saying that he wants an inquiry, Your Lordship, and FIRs have been launched. But 3 and 5, Your Lordship, are directly service matters. Your Lordship may kindly have a look at the prayers in 3 and 5. He is asking for the setting aside of the appointments of certain officers. And in 1, he has said that some people have been wrongly promoted, their promotions are bad, and they should be set aside. And the law is settled regarding that, Your Lordship. PILs cannot be there in service matters. So that is regarding 3 and 5. And regarding 1 and 2, Your Lordship, he has already filed FIRs. And under Section 8 of the Assam Agriculture University Act, the Chancellor, who is the Honorable Governor, has a power to conduct an inquiry, which he has said that he has submitted representations. So we should perhaps wait for the outcome of the inquiry. Now, regarding the issues raised in 1 and 2, Your Lordship, regarding embezzlement, using of university resources for foreign trips, etc., those were raised earlier also, Your Lordship. Several PILs have been filed before in this Honorable Court. I had the orders. In fact, the governor caused an inquiry through a former Honorable Justice of this Honorable Court, Your Lordship. In the inquiry also, nothing came out, Your Lordship. Those are my instructions. But he has an alternative remedy, and which he has exercised. Without waiting for the outcome of the process, Your Lordship, perhaps the PILs are a little premature, Your Lordship. This is the judgment passed in the earlier round, Your Lordship. On similar grounds, this PIL has been filed.
Have you seen these orders?
Your Lordship.
Acha, then what we'll do is, you bring these documents by filing a short affidavit.
Lordship.
We'll take it up Monday or Wednesday.
Lordship.
Wednesday,
Lordship.
we'll have these matters on Wednesday.
Very well.
He is entitled to an opportunity. To-
Yes, Your Lordship.
Mr. Bhagavate, I have, or we have rather had a cursory glance. 2 of the PILs you are raising issues of service matter.
Lordship, these are scams, Lordship.
Hmm.
What I have pointed out are, these are scams, Lordship, and should be treated as scams, Lordship.
No, wrong appointments, unless you put a FIR, you see, all these matters,
Gotcha.
let us point out the jurisdiction.
Lordship.
We are not going to inquire into any of these
Lordship.
allegations.
Lordship.
We are not even going to find out whether these are true or
Lordship.
false.
Lordship.
Only thing we'll see is that if a citizen has a right to file a PIL,
Lordship.
and in that PIL, please raise that although he has taken steps to put the legal machinery
That's it.
into motion
Lordship.
for some mala fide reason,
Lordship.
some authority is sitting over the matter.
Lordship. Lordship.
That is the only area we'll look at.
Lordship. Lordship.
And of course, in a PIL, the antecedent of the petitioner is important.
Lordship.
Merely because he belongs to a political party, that
That's it.
may not be a ground to non-suit the petition.
That's it.
But if there are other attending factors which even remotely hints at some personal rivalry,
That's it.
some vested interest, then the courts will not entertain
Lots
such PIL.
Understood, that's it.
So to have that minimal satisfaction,
That's it.
let him file
Lots
his
of-
affidavit.
That's it.
We'll have it on next Wednesday
That's it.
for motion only.
That's
In all these matters, common order, heard Mr. M. Bhagawati, learned counsel appearing for the petitioner in all these petitions. We have also heard Mr. K. P. Pathak, learned standing counsel,
Assam Agriculture.
Assam Agriculture University, who submits that these petitions are not maintainable in law and facts. First up, it is also the submission of Mr. Pathak that the antecedents of the petitioner raises serious doubt on the bona fide of these proceedings, and therefore he be given a week's time to file an affidavit bringing on record certain facts which would go to show that the petitions are not maintainable in law. Also, considering the nature of controversy involved in all these petitions and taking note of the submission of the learned departmental counsel, we are inclined to grant a week's time to Mr. Pathak to file a short affidavit on the point of maintainability by serving advance copy upon the petitioner's counsel. Register to list these cases together again on next Wednesday. What is the date?
25th.
Eh? Wednesday will be 26. Let it be after, let it be on 27th,
Republic Day, after Republic Day.
27th, 27th.
That's it.
Let it be on 27th, 27th.
Very well.
Yes. That's all.
You file a affidavit bringing all these orders.
Yes.
He should know what is what.
Yes.
Item number 4.
Yes, what is
Lordship,
this?
I think your lordship, annexed to page 16. There is inquiry report. Page 16 and 17. sir.
Where is the proof of financial misappropriation of this amount?
Lordship, this is the only inquiry report, Lordship, and
Which is the inquiry report? Which,
Lordship, page 16. It was done by block development officer, and Lordship kindly also come to page 32. There is a shock. Notice issued by the executive officer, Lordship, chief executive officer, Qatar, Lordship. Page 32, election 5.
so you are saying they are guilty of corruption?
Lordship, and Lordship is also did not obeying the any of the authority, higher authority. So repeatedly shockers were issued, and he is doing this. We made a complaint, Lordship, that is Lordship, kindly come to page Lordship, annexure 7, Lordship, page 40.
Annexure,
Annexure 7, page 40. It is to the district magistrate cum deputy commissioner Kachar Lordship, and copy was served to the principal secretary to the government of Assam, commissioner PNRD, and other. No action will be taken.
so the complaint is against the president of the Gaon Panchayat.
President and secretary, these are the two persons mainly responsible for all this.
Right. So if there are financial embezzlements,
Right.
then you have to make a complaint before the chief minister's vigilance
Lovely.
cell. And insofar as if they are not conducting the affairs in a proper manner, then the remedy is to move a no confidence motion against the president. So that is the reason we cannot, we regret our ability to entertain your PIL. These are not subject matters of PIL. But we'll give you liberty, you file it. You make your complaint before the CM vigilance cell. And for other matters, you can always, because if the majority of the people thinks that he is doing it fine, that's so be it. The court cannot do anything about this thing.
Lordship secretary also.
Have you understood it?
Lordship-
Because we'll dictate the order now.
Lord-
You want to say something, you say. This is not
But,
for the writ court
secretary
to
also, Lordship, my another submission, Lordship secretary also involved.
make a complaint. If they are involved in financial embezzlements, there are machineries to look into it. Deputy commissioner is not the machinery. Deputy commissioner cannot do anything about it. So we advise your clients properly instead of rushing with a PIL. PIL is a very extraordinary remedy. Only when the people are unable to move court, take action under the law, some bona fide citizen can come forward. This is not a forum to indulge in when there are other remedies available. These are private law issues. You have understood?
Lordship,
You are for whom?
PNRD, my lord.
PNRD. What do you have to say?
Nothing, my lord. Your lordship has
You have no scope to say anything after that.
No, nothing at all. my lord. My lord has laid the law here.
We'll give you liberty.
Lordship.
All right. Heard Mr. L. R. Majumdar, learned counsel, appearing for the petitioner. Also heard Mr.
P. Handick, my lord.
P. Andy, learned standing counsel, PNRD, Department Assam, appearing for the official respondents. Mr. Miss Reddy, learned government advocate Assam, is present on the office. Respond number 3. Stop. This public interest litigation bracket PIL bracket close has been filed by the petitioner. Who is the petitioner?
Lordship Tahir Hassan.
No, that we know. What is he? Who is he?
He is a local resident of that particular GP, Rangirghat GP, Lordship, and he is a social worker. Lordship.
Who claims to be a social worker and a resident of the Gaon Panchayat in question, alleging that the respondent numbers 6 and 7 have indulged in embezzlement of public fund to the tune of rupees 2,27. You have not even put the figure correctly. What is the amount? What is the
Lordship,
figure?
2 crore 27,093.
2,27 lakhs, 93,03.
Yeah.
Which amount is liable to be recovered from them? Full stop. It is also the allegation of the petitioner that the respondent number 6 and 7 are not conducting the affairs of the Rangirghat Gaon Panchayat situated in the district of Kachar, Assam. Full stop. After going through the averments made in the petition, we find that the allegation of corruption and or embezzlement of fund can be dealt with by appropriate agencies in the state who are authorized to look into such matters. First of, however, the petitioner has not made any complaint to those agencies till date. First of, insofar as misconduct on the part of the respondent number 6 and 7 is concerned, here also the respondent number 7 being an elected resident of the Gaon Panchayat, the remedy against him is provided under section 15, bracket 1 of the Assam Panchayat Act 1994, is it?
1994.
1994, full stop. Insofar as the allegations brought against the secretary of the Gaon Panchayat, that is respondent number 6 is concerned. The petitioner has the option to approach the competent authority in the government of Assam, namely the
Lordship,
director of, is it?
no, Lordship,
Who is the appointing authority?
Lordship Panchayat
Who is the appointing authority of the secretary?
Secretary, Lordship.
Petitioner has the option of lodging a complaint before the appointing authority, which he has failed to do as on date. Full stop. Under the circumstances, we are of the view that no good ground for entertaining this PIL has been made out by the petitioner. We accordingly close the matter. Full stop. However, the petitioner is granted liberty to avail appropriate remedy as may be permissible under the law, if so advised. PIL stands disposed of.
Obliged.
All right.
Matter number 6 for admission.
May I please, Lordship? Lordship, this appeal is against conviction under section 6 of POCSO Act. The appellant.
We'll admit it, it's a appeal
Lodge,
against conviction. You're Mr.
M.
M.
M. Pathak.
Heard Mr. M. Pathak, learned counsel appearing for the appellant. Also heard Ms. S. Jahan, learned APP Assam, representing the state. This appeal against conviction is directed against the judgment
11/11/22.
dated 11/11/2022, passed by the learned special judge command Nalbari in connection with special bracket P, bracket close, case number 15/2020, convicting the sole appellant under section 376, is it?
No, not
Six.
okay. Six, only 6.
6 of the
Appellant under
POCSO.
section 6 of the POCSO Act and sentencing him to undergo simple imprisonment for 20 years
20 years.
and also to pay a fine of rupees 30,000
In default, 6 months.
with default stipulation. Stop. We have perused the impugned judgment and also and have also considered the submissions made by learned counsel for both the sides. Full stop. Admit the appeal, call for the LCR, issue notice returnable in 6 weeks. Since the respondent number 1 is represented by the learned APP Assam, no formal notice is required to be sent to the said respondent. Full stop. Appellant to, however, take steps for service of notice upon the
Respondent
the-
number 2. victim.
respondent number 2 oblique victim
Yes.
by registered post with AD within a week from today.
Okay, we have filed an IA for interim order.
There I find my objection. A victim should not have been made a party here by name. And
What to do?
Yes.
Our learned counsels sometimes apply their mind, sometimes they don't know. It's now a big news. Everybody knows that you should not name a victim in a proceeding. He
mother
also
was
knows,
the informant.
but
so
maybe he
mother-
has not applied his mind, is it not?
Yes, Lordship. I am very sorry.
Sometimes you should apply your mind.
Yes.
Don't do it always.
Yes.
Hmm.
I find my objection. 2 weeks.
আগৰ order লিখিব. However, registry to blur the name of the victim in the petition. And also at the time of issuing notice upon the victim. Name of the victim. Huh? In IA, you write, heard Mr. M. Pathak, learned counsel for the applicant, also heard Mr. Jahan, learned APPS appearing for the state. His IA has been filed under section 389 bracket 1 of the CRPC with a prayer for suspension of sentence and also for the release of the applicant on bail during the pendency of the connected appeal. Stop. Ms. Jahan prays for 2 weeks time to file objection. Prayer allowed. List this matter after 3 weeks or immediately after the objection is filed by the state, whichever is earlier.
Matter number 7.
Appeal against acquittal, Lordship.
Appeal against acquittal.
Acquittal, they were acquitted from the charge under section 302 There are 4 eyewitnesses in the case who are injured also. So at this stage, Lordship, we admit the
Appeal is by informant.
informant. This is the victim also because mother has died.
Will issue notice?
Yes, Lord.
Heard Mr. Zaid Alam, learned counsel for the appellate. This appeal preferred by the informant is against the judgment and order of acquittal dated 3/11/2022, passed by the learned Sessions Judge, Barpeta, in connection with Sessions case number 28 of 2013. Full stop. We have perused the impugned judgment and have also considered the submission made by the learned counsel for the appellate. Stop. Issue notice returnable in 8 weeks. Since Ms. S. Jahan, learned APC Assam, has appeared and accepted notice on behalf of the state respondent number 1. No formal notice is required to be sent to the state respondent. Appellant to take steps for service of notice upon respondent numbers 2 to 5.
Yes.
Are registered post to the AD within a week from today.
2 to 6.
2 to 6? Yes,
Yes.
2 to 6.
Give it.
The numbers 8 and 9.
Meet with your also. Look, in this matter, by the last order, there was a direction by this honorable court to the member secretary to involve the secretary, DLSA, and the executive engineer concerned of the district for construction of
What is the
VWDC.
matter? What is this?
Basically, at present, we are concerned about the creation of vulnerable witness deposition center.
Hmm.
This is basically a PIL for protecting the juveniles. Interest of the juveniles. But at present, by the last order, we are concerned with creation of vulnerable witness deposition centers in the various places. Already 17 already constructed.
Yeah, it's
For-
going on.
It's going on. Remaining, there was a report by the member secretary on the last occasion, wherein there are remaining courts wherein, the VWDC is yet to be, erected. Now, this honorable court on the last occasion, expressed a view that not a new construction, even the existing building, some space we can arrange and we can create a VWDC in the existing building of the courts wherein it is still to be done. So in that context, this honorable court passed an order that let the DLSA and the executive engineer concerned have a joint visit to the court and see whether it is feasible or not and file a report. But due to the Bihu vacation, the things could not be done. So if taken up,
The member secretary has to submit a report now.
So who is representing the member secretary?
I am appearing for
You are appearing for whom?
for the High Court as well as the member secretary.
Who is for the petitioner?
No, it's
There are 2 cases, I am appearing in item number 9. And item number 8.
We are appearing, we are for the petitioners here, Lordship.
You are for the petitioner.
For the petitioners in item 8. This arises out of the same judgment, Your Lordship, the Sampurna Behura case,
Hmm.
whereafter Suomoto PIL was drawn by this court. That is item number 9 before this honorable court. And item number 8, Your Lordship, is the PIL which has been filed by Bachpan Bachao Andolan. Certain guidelines were framed under the Sampurna Behura case, whereafter, Your Lordship,
Hmm. So these member secretaries are to submit individual reports directly to the court.
to the court with a copy.
I'm told that they will take some time.
The DLSA will send the reports from the districts to the member secretary here, and he will prepare a report and submit it before the court. Compilation of the various reports.
All right, so
Maybe
then.
taken up in the next week, Monday or any other convenient date.
They need some more time, Lord, I'm told.
The Monday is not going to work out. Now,
No.
next week you have the Republic Day and other things. We'll have it after 2 weeks then.
Lordship.
But actually, these matters are taken up every week previously by this honorable court. Because
No, what is the reason?
the reason is that court wanted that this infrastructure regarding VWDC.
All
should
right, we'll
come
have it
as
on
it-
Friday then, next Friday. Next Friday.
Next week, Friday.
27.
Fine.
Yes, you take down heard Mr. N. Chaudhary, learned counsel appearing for the petitioner in item 8. Also heard Mr. H.K. Das, learned standing counsel GHC appearing in item number 9. Full stop. Mr. D. Nath, learned senior government advocate Assam is present on behalf of the official respondents. By inviting the attention of this court to the order dated 9/1/2023 passed in these proceedings. Mr. Das submits that the report called for by the aforesaid order could not be placed today since there is some delay in receipt of feedback from the respective district DLSs. Full stop. Mr. Das submits that the intervening Bihu holidays have delayed the process and therefore a week's time be granted to the member secretary of Assam State Legal Service Authority to place the gist of the reports in the form of a compilation before this court. Prayer is allowed. Registry to list these cases again on 27/1/2022, 2023.
Deeply observed.
All right.
Call correction, please. What is it?
The number 13.
Acha, Mr. Saikia, perhaps somebody has asked for a remote VC here. We have granted it, but we will take it up after the other matters are over.
Lordship,
Kindly wait for a little while.
Lordship, notice.
All right, we'll take it up after other matters.
Lordship.
The number 14.
May I please, Lordship? Lordship, in this case, I am appealing for respondent 6. Respondent 6. Because I pay for some more time left. My client is already retired due to some personal difficulty. Though I prepared the affidavit, could not come today. So I pay for 3 weeks time to file affidavit.
All right, Mr. Hard,
Only
Mr.
2 weeks, Lordship. Otherwise, they have taken a lot of time.
Lordship,
Lordship, may kindly see. Lordship.
3 weeks,
Question.
otherwise, again, it's because a retired person.
What is this matter about?
This is with regard to the cultivation. Lordship, there are
What-
some
what
lot
is
of
this PIL about?
misappropriation of Lordship.
What is this PIL about?
Misappropriation of the Lordship fund. There is a Lordship audit report, Lordship, an amount of 16,72,000. 03 Lordship, that has not been deposited in the government. And that was, that fees was collected for students, and there are other anomalies also. There are umpteen number of conversion of posts in this college, Lordship.
Lordship, if on merit, my lord, this PL is not maintainable in my case because he is not the party who were at the particular time were holding the post. My lord. I am since July 22 until 31st of December, I was the principal in charge and DDO.
Acha, let him file his affidavit.
Lordship.
3 weeks last chance.
Lost,
huh?
lost.
No further ado.
Lordship.
Heard Mr. S.K. Das, learned counsel appearing for the petitioner. We have also heard Mr. M. Mohammed, learned counsel representing the respondent number 6. Who prays for 3 weeks further time as final opportunity
Lordship.
for his client to file affidavit
Lordship.
in this case. Full stop. Who else is there? Mr. S. Bhuya is present on behalf of respondent numbers 1 and 2.
Respondent number 4.
And Miss R. Mehdi has appeared for the respondent number 4. Considering the nature of issues involved in this proceeding, we deem it appropriate to grant 3 weeks further time to the respondent number 6 as last chance to file affidavit. Let this PIL be listed again after 4 weeks.
Okay. Number 15.
This PR relates to the medical college, Nalbari Medical College, where the estimate to be short within a period of 1 year from 2 crores to up to 90 crores. And most of the work relates to underground. Underground, it is justified, it may not, we find when it is not justified.
Lordship, may kindly grant us 1 week time. My colleague, Mr. B. Chaudhary is not well. He wants to file the affidavit in the matter. It is otherwise ready, I'm told.
What is this noise coming? Acha, somebody is online. Acha, we'll take it up. We'll take up item 30. Who is the council? You tell him that we'll take it up after this matter.
If they are wanting.
The
1 week
council
time-
should be informed that we'll take up the matter. Item 13, is it? Is it? Yes. We'll take up the matter.
They want for 7 days. But
I
notice
heard
has
Mr.
not gone to
B.D.
the-
Das, Lanet Senior.
Notice
Counsel.
has not gone to the private respondents,
Notice has not been issued.
not been issued to private respondent.
Who is the private respondent here?
It's the Gautam Construction. Let's change
That is the contractor.
yeah. What be requesting, my lord, your lordship will see whether it is justified within a
Okay,
period.
let
of
them
1
first file the
Right.
affidavit, then heard Mr. B.D. Das, Lanet Senior Counsel listed. E. Kolita appearing for the petition. Also heard Mr. D. Nath, Lanet Senior Government Advocate Assam, appearing for the official respondents who submit that the affidavit in this case is ready, but Mr. B. Chaudhary, Learned Standing Counsel, who is handling the matter, is unwell, and therefore the affidavit could not be brought on record in the meantime. Full stop. Mr. Nath, therefore, prays for 1 week's further time to file the affidavit. Considering the ground on which the prayer is made, the same stands allowed. The registry to list this case again on 1st of February 2000. No, let it be 30th of 31, 2023 as a fixed item. In the meantime, the official respondents to bring their stand on record by filing affidavit. Yes. Abla, you.
Number 16.
May I please your lordship? Lordship, today matter has come up for suspension of contains lordship for consideration of higher lordship.
I have come up for the first time today.
Lordship. And they have not yet filed objection lordship. We have not
So
received
today it has come up for the first time. I'll file my objection. Appeal was listed earlier.
Lordship.
How much time you
2
want?
weeks.
2
2
weeks
weeks I'll
time.
file my appeal.
All right, you are Mr. M.A.I. Hussain, is it?
No, lordship. Ayu Chaudhary lordship. On
Ayu
behalf of
Chaudhary,
Ahmed
all
lordship.
Heard Mr. Ayu Chaudhary, learned counsel for the applicant. This IA has been filed under section 389(1) of the CRPC with a prayer for suspension of sentence and also to permit the applicant to go on bail during the pendency of the connected appeal. First of Ms. S. Jahan, learned APP Assam, appearing for this state, submits that this IA has been listed today for the first time and therefore she be granted 2 weeks time to file objection. Prayer allowed. The state oblique respondent number 1 to file objection within 2 weeks. List the matter accordingly. All right.
Lordship, reminder may be issued in the in response.
No, it can't be done in the IA.
Lordship, LCR not received lordship.
The reminder has to be issued in the main page.
Lordship. Lordship. How lordship?
Number 17.
Yeah, please, Lordship. The appeal is against order dated 18/6/2003 in session case number.
Delay of 6,259 days.
Yes, you're right.
Why such long delay?
Actually, the children accused were the minor and just major, and they were from very poor family, belong from poor family, and illiterate. That is why they have no idea that the legal relief are there. So actually, delay occurred for them, and 19 years has been behind the bar.
Oh, they have been behind the bar for 19 years.
Yes, my lordship.
19 years.
Yes, my lordship, because they were arrested on 11/12/2002. Since then, they are behind the bar. That's it.
No, but the imprisonment is for 10 years. Imprisonment is for 10 years. How can they be behind the bar for 19 years?
Life, they have been given for
Their
life.
life will
302 is life
life is
and
there, your lordship.
364 is 10.
Life is also what? With parole and other, it is 15 years.
But then life is
Yes.
life unless it is remitted under the CRPC.
Remissions are granted under the jail, madam.
Remissions are granted, that is.
What do you
again-
have to say?
Let us go into the merit ones.
All right, third, Miss R. Goswami, learned counsel. Will you? Will you allow her to?
Legally. She is from the legal.
Legal aid.
Legal aid counsel appearing for the applicants. Also heard Miss S. Shah, learned APP Assam, representing the state. This IA has been filed under Section 5 of the Limitations Act 1963 with a prayer to condone the delay of 6 to 59 days in filing the connected appeal against the judgment and order dated 18/6/2003 passed by the learned Sessions Judge Nalbari in connection with Sessions Case number 02/2003, convicting the applicants stroke appellants under Section 147/364/302/201/387 of the Indian Penal Code bracket IPC and inter alia sentencing them to undergo rigorous imprisonment for life and also pay fine with default stipulation system. By referring to the statements made in the IA, Ms. Goswami submits that the applicants were minor, illiterate,
Just major, my lord.
Applicant.
both the applicants were of tender age when they were convicted, and due to their illiteracy and
Poor things.
poverty,
Yes, poverty.
the applicants could not take steps for preferring the appeal against conviction. First of subsequently, when the matter came to light, the legals, they approached the
For illegal, yes, illegal.
subsequently, when they became aware of their rights, the applicants had approached the legal services authority seeking legal help to file the instant appeal. Stop. Considering the facts and circumstances narrated in the IA, Ms. S. Jahan, learned APP Assam, submits that she will not file any objection in the matter. In view of the above and taking note of the explanation furnished in the IA, we are inclined to condone the delay of 6,000 whatever days in preferring the appeal. The delay is accordingly condoned. Office to register the connected appeal and list the matter for admission. ISS disturbance.
Large.
That's it. My bail petition is also there. If they allowed to go from doing bail.
No, that once the appeal is listed, then you proceed.
Okay.
Number 18.
Item number 18 is a state appeal against acquittal. The 7 accused persons were acquitted under NDPS.
Mrs. John, learned APP Assam.
This is a leave application.
This IA has been filed by the state seeking leave to prefer an appeal against the judgment and order of acquittal. Full stop. We have perused the grounds taken in the application. Stop. Issue notice returnable in 8 weeks. Applicant to take steps for service of notice upon the respondents by registered post with AD within a week from today.
Obliged.
Number 19 for hearing.
19, my lord, I'll seek some apology. Last date also, my lord, I had sought some time to produce a status report, my lord. my lord, another apology, my lord, I'll seek a fix again sometime.
How many apologies? First decide.
Two, my lord, this is
Only
second,
two.
this is the final one, my lord, no more further apologies, final date, my lord.
Final
A
date.
final date and.
Final apology, final date.
No, short date won't do because my lord, officers who has to instruct me they're busy with Gonot.
Oh, then how can you say it is final apology?
My lord,
How are you sure it is final
no,
apology?
I had persuaded them, so they have sought through me.
Have you
finally.
taken their consent before giving the
Yes,
final? Huh?
I have verbally, I have asked them. They said no more dates. Please pray for this time only.
What to do?
Should be the last time that may be.
That may be recorded.
Should be the last time that may be granted.
That can be recorded.
What is the matter about?
The suo moto PL instituted against.
Illegal mining in the Tipam area, Lordship.
Hmm.
Lordship, illegal coal mining, Lordship, a newspaper report was published and on the basis of that, this suo moto
Illegal mining in Tipai,
Tipam area. Lordship.
Tipam, my lord.
Tipam.
Tipam area.
Everybody.
And you are appearing for whom, Mr.
I appear for the forest department.
Forest
Forest
Department,
department.
State of Arunachal Pradesh. Are you
And
also?
for the other departments of the state of Assam, Lordship.
All right. Mr. Ahmed is also there. All right, all right. The issue raised in this public interest litigation bracket suo moto pertains to the alleged illegal mining activities going on in the Tipam area in the district of
Dibrugarh.
Huh?
Dibrugarh.
Dibrugarh. Full stop. This matter was fixed for hearing today. However, Mr. D. Gogoi Learned Standing Council
Forest department.
Forest Department submits that the instruction stroke report called for by this court has not yet been received by him. Full stop. By tendering apology for failing to comply with the court's order, Mr. Gogoi prays for 3 weeks further time as last chance to produce the report. Full stop. Mr. MZ Ahmed Learned Senior Counsel assisted by Mr. AM Datta is present on behalf of respondent number 8, 10. Full stop. Mr. BD Goswami, Learned Additional Advocate General Arunachal Pradesh has appeared for respondent number 11, and Ms. M. Bhattacharjee, Learned
5 to 9 and 12.
Government Advocate Assam is present on behalf of respondent numbers 5 to 9 and 12. The prayer made by Mr. Gogoi has not been opposed by either sides. However, the petitioner's counsel has prayed for a firm date with a request not to grant any further adjournment in the matter. Full stop. Taking note of the submission of learned counsel for both the sides, registry is directed to list this matter again on 13th of February as a fixed item.
Right.
Yes.
Number 20 of supplementary.
Mhm.
We have seen, my lord, by the revenue department, my lord, the writ petitioner, my lord, filed a writ petition before the learned single judge, my lord, claiming an spiritual compensation on account of my lord, alleged, my lord, untraceability of her husband. My lord, the husband of the writ petitioner was, my lord, kidnapped, my lord, and abducted by some unlawful organization in the district of Karbi Anglong. My lord, the state authorities made investigation and his dead body was not found. Finally, my lord, seeking compensation and especially this writ petition was moved. My lord, the honorable single judge, my lord, after perusal of the materials on record and the affidavit filed by the police authorities came to a conclusion, my lord, that although there is a scheme under the policy of the state to grant an SBC of rupees 3 lakhs, but it has been, my lord, increased to the quantum of rupees 10 lakhs. Hence this appeal, my lord. We took the leave of this honorable division bench, my lord, while preparing the appeal. That leave application was also allowed. And my lord, there was a delay of 322 days. That delay was also condoned. In the meantime, my lord, during the hearing of this appeal, an amount of 3 lakhs has already been paid, my lord, to the writ petitioner. This is the admitted position. Now, if
So learned single judge is ordered how much?
10 lakhs. And we have paid, my lord, 3 lakhs. That is, there is a scheme under the policy.
Pay some more.
But more, my lord, we are resisting, my lord. And more, my lord, we are resisting, my lord. We are, my lord.
Why?
Because, my lord, under the scheme of the state, my lord, there's a scheme, my lord,
Hmm.
policy of the state. Whereby, my lord, in these types of cases, my lord, and as we said, the end of rupees 3 lakhs is paid, my lord, to the next of kin of the victims. And more often, my lord, these writ petitions are coming, my lord, before this honorable court every now and then. And all the writ petitions are disposed of, my lord. The deputy commissioner is directed to make an inquiry. If found entitled, 3 lakhs is paid. So it is going on in that way. However, my
So
lord, in
this has come for admission.
no, this is for hearing. In the meantime, my lord, I am told, my lord, that the councils appearing for the repetition who happen to be the respondents out here, there is a change in councils. Last, my lord, my learned colleague, my lord, P.D. Nair, he was appearing, he was defending on behalf of the repetitioner in before this honorable court. But he had, my lord, returned the brief. In fact, my lord, the brief has been taken by the private respondent number 1 here.
Then fresh notice has to go.
Yes, notice, my lord, I have checked the website, my lord, where I have found that my lord, a new wakalatnama has been filed by one Mr. N. K. Muri. On
But
eight-
his name, has his name been
Yes,
shown?
yes, it is also reflected in the first list.
Mr.
Lordship,
Muri
my-
must be still in the Bihu.
My lordship, may be pleased to post this matter on any other day. I'm not sure.
Heard Mr. R. Borpujari, learned Standing Council Revenue and Disaster Management Department, Assam, appearing for the appellant. This appeal has been listed for final hearing today. First up, however, we find that none has appeared for the respondent. Respondent number 1,
One,
who was the writ petitioner.
my lord.
Who is the writ petitioner in this case? First up, it appears that there has been a change of counsel. And the newly engaged counsel has also filed his wakalatnama. First up. However, none has appeared for the respondent number 1 today. First up, considering the nature of issue involved in this case and the consequence that may ensue upon the respondent number 1 if the appeal is allowed, we deem it appropriate to post the matter on some other day so as to enable the learned counsel for the respondent number 1 to appear and argue the matter. Full stop. The registry is therefore directed to list this appeal for hearing again after 4 weeks
My lord,
by reflecting the name of learned counsel for both the sides in the call list.
my lord. And so, obliged.
Yes. Baki ho gaya. Yes, what is,
May I please, your lordship?
where from, who? Huh?
Your lordship, I am the petitioner in person.
No, you're petitioner in person.
Yes, your lordship.
Yes, where are you now?
I'm in New Delhi.
You're in New Delhi.
Yes, your lordship.
Why are you appearing through VC and not personally?
Your lordship, New Delhi is my workplace and I was in Guwahati in last date of hearing. So it has become very difficult for travel.
Okay, okay. So you will continue to appear through VC, right?
Sometimes, your lordship.
Okay, okay. What is this matter about?
Your lordship, this petition raises the issue of the violation of the rule of law and equality of law and equal protection of laws. What we have seen that the police person in the state of Assam has been in a shooting.
Just a minute. Who's
The learned advocate is on this way, my lord. He'll be here in a minute.
he's appearing in this?
Yes, my lord.
Yes. Yes.
May I? Yes, yes, lordship.
Yes. First of all, you are the petitioner, is it?
Yes, your lordship.
Who are you? What is your antecedent? Let us understand. You are a practicing lawyer.
Yes, your lordship.
Okay. What do you want in this case?
My prayer is for an SIT or a CBI investigation in all the fake encounters which has been occurring for the last 1.5 years in the state of Assam.
All the fake encounters.
Yes, your lordship.
Which are the fake encounters according to you? Where are the particulars?
Lordship, according to the government affidavit, there have been 171 incidents of police firing, wherein 56 persons died. And till now, I have received 74 FIRs. In those FIRs, it has been clearly found that no PUC judgment has not been followed So all these encounters are fake. Your lordship may kindly see pages 124 to 159. May kindly see page 141 directly.
One
141. It's the running page number 141.
Yes.
In the affidavit, the state government, the respondent one has annexed few of the ministerial inquiry reports, wherein the magistrate himself has stated that wherein 6 DNLA cadets killed, there were no forensic investigation, for ballistic report was not there. And in pages 144, 142, the same, all the ministerial reports, if we see, there have been a lapses in investigation. Magistrate himself has stated in their reports.
So what do you want? Let us see your prayer.
For an SIT investigation.
Investigation.
33, page 33.
So you said you are from Delhi, is it?
Yes, Your Lordship. No, I am from Assam only, but I practice in New Delhi.
All right. Now, how do you know that these are all fake encounters? What is the source of your information?
Your Lordship, may I recall one incident of Nagaon, wherein a student leader was shot. At the first instant, the police gave the statement that he was a drug dealer and so and so. After hue and cry, the state of Assam ordered for an investigation, and that investigation had held that the encounter was a fake in the state, in the town of Nagaon. I forgot the name of the case was some Bora. He was a student leader. His name was some Bora.
Oh, don't say some Bora. You're not
I'll come to the point. I'll come to the point. There is a landmark case, that is a PUCL versus state of Maharashtra. That is the law of the land that stipulates some guidelines which has to be followed after each and every encounter, after police firing. But going through the FIR, what I have found, even I have submitted that in a compliance affidavit, that not a single provision of that PUCL judgment has been followed by the by the respondent number 1. And it is very clear, when the investigation has not been done in terms of the PUCL judgment, then we have to find out whether through an SIT or CBI investigation that whether they are fake or not. If the respondent has been saying that this is not a fake encounter, okay. If there's intent, let the Honorable Court order for an investigation, then it will be clear.
No, but Mr. What is his name?
I'm Arif, Your Lordship. Arif.
Arif. You see, these persons who are the victims of, let us say, in your words, fake encounter, which may or may not be correct, we don't know. Their family members are unable to approach the court.
Because of fear. Because of fear.
Because of fear.
Yes, when a family member has been shot, one family member has been killed, because of fear, they are not coming out. Only one person, because he was a student leader from a particular organization, then he came out. That investigation was done. Only in one case, investigation was done, and it was held that to be a fake. That means 100%. If 100 and 171 investigations are held in 100 and 171 investigation incidents of police firing, then I'm pretty much sure that all those will be held fake. Because your lordship may kindly see the latest affidavit in opposition, which has been provided by the respondent number 1. They themselves has stated that independent investigation has been held in 75 incidents of police firing. Ministerial inquiries in 92, police inquiry in 122. FSL forensic was done in only in 48. Ballistic test was done only in 40 out of 171. They have themselves admitted. But PUCL judgment says otherwise, that every investigation has to be done, independent investigation has to be done in every police firing. They have not done it. So what they are hiding? They are hiding something. And for that, an independent investigation has to be ordered by this honorable court. Only things will come clear.
Yes, anything else?
Your lordship, my IA is also pending since last 1 year. My IA may be taken and disposed on merit.
What is the IA?
I have sought for some documents. Your lordship, in the PUCL judgment, may I, your lordship?
1 minute, please. So FIR has been registered in each and every case.
No, your lordship. They are stating that FIR has been registered. But what I am saying is FIR has not been registered because these FIR are against the victims. The PUCL judgment says that the FIR has to be against the police personnel, not against the victims. What they have provided the FIR numbers, may kindly see in the latest additional affidavit in opposition. It starts from page 317 to page 355 of the affidavit. They have provided only one FIR number in each cases, in each of the individuals. So it is very clear that there is only one FIR. But the PUCL judgment states and stipulates that there has to be an independent investigation, and for that independent investigation, there has to be separate FIRs. That has to be against the police personnel, not against the victims. It cannot be the case that a person who has died and an FIR has been lodged against that person. How can he defend himself? And your lordship, in every case, the police has claim for a self-defense. But the self-defense is a legal defense. Only when an FIR is lodged, then only police can claim that legal defense, self-defense. Without an FIR, they cannot claim that. Moreover, your lordship, they themselves have admitted that there have been only 75 independent investigation, so-called independent investigation, out of 171 incidents of police firing. So they are themselves admitting that they have not done independent investigation. The PUCL judgment starts from page 103 to 104 of the main petition.
Who is appearing, Mr. Saikya?
Lordship, I am appearing. Our case is very simple, Lordship. If the petitioner wants to say that there is some deficiency on our part, they have to pinpoint us. Just saying 175 killings, 75 FIRs, that will not.
Omnibus petition.
There's a very big. If he has any grievance, Lordship, let him file specific case, in which case there is any lacuna on our part.
That's just what we wanted to ask him.
Yes,
because
Lordship.
It's a very
The-
broad thing. he
Because
has
when
filed.
it was filed, it was long time back. And he was asking us to provide him the FIRs. If he is a lawyer, he knows how to procure a FIR copy. Let him first do the FIR investigation about the various factual parts. If there is any lacuna, thereafter, Lordship, we are definitely, Lordship, will answer.
Your Lordship,
Submission is very clear.
Just a minute. Let him submit. We'll hear you again.
My
Yes.
submission is very simple. Let him point out each individual case where there is any fault on the part of the state. Our case is very simple. We have followed all the requirements as per the Honorable Supreme Court judgment of 2014. All the cases, FIRs are lodged. It has been investigated by independent agency, the police team from the outside the district.
He is alleging how many encounters?
That figure also he does not have.
Yes, how many encounters you're saying? How many?
has admitted in their own affidavit, 171 in police firing,
100 and
171. It is in page 321.
So you have clubbed all this together, these things, Mr. Arif, Mr.
May I read this paragraph, Lordship?
Just.
Which my
one
learned
minute.
friend is.
Mr.
I'm
Arif,
sorry.
Yes, Your Lordship.
please consider one thing. Your allegations may or may not be correct, we don't know. But we cannot make an omnibus approach. We have to go by the facts of each case and give our finding. Listen. If you don't want to listen, then you do your part, we'll do our part. Listen, if you do not give us the specific facts of specific case, how do we write a judicial order? We can't go on an omnibus thing that 117 incidents have happened. In not a single case, this has happened, not a single case. That kind of a view is not possible. We have to go in each case, whether there is violation, if there is a case of violation of human rights, procedural violations, to what extent the relief can be granted, what are the remedial measures. It can't be a whole hog thing. What you have done is you have clubbed so many, we don't know, some case there may be violation, some case there may not be violation. How do we segregate this? How do we segregate all these things? We have to write individual judgments for each case. Why have you clubbed all these things together? Maybe you have a point, maybe you don't have a point. You don't expect the judge to go and find out in every case what has happened. Each case could by itself merit or not merit an order of the court. But you have done it in an omnibus manner, as if so many killings have happened, so many things, so go for a SIT. We cannot write a judgment like this. We have to record specific finding that in this case, this has happened. So therefore, this remedy is called for or not called for. What do you have to say on that? Before we pose this.
Your Lordship, may kindly see pages 323 to page 355. Respondent in its affidavit has annexed a list wherein they have given the case reference, police inquiry report, some so and so in a box, in a column form. On prima facie, it seems that they have not done ministerial inquiry, independent investigation. They have themselves admitted. And I have given through an affidavit.
Before we want to hear the Advocate General, we want to ask you one thing. Oh, please switch that off. Are you willing to withdraw this and come up with individual petitions on individual instances? In which case we can ask them. We can ask them to specifically respond. And if we are not satisfied, we can pass an order of specific inquiry in a specific case. Are you willing to do that?
Your Lordship, they have responded even after the order dated 25th February and 8th December, and had provided me the FIR copies complete. I have so far got 74 FIR copies. There has to be 171 FIR copies. They have not provided.
Give them the FIR copies. That FIR copies they'll give you.
They have not provided yet.
For the last 1 year, I have been pass an order asking them to give you. What is your problem?
No difficulty, absolutely no difficulty. But any Tom, Dick and Harry can go to the prosecution court, file an application
That's
for submission of.
No,
They
Your
don't
Lordship,
have to teach
no,
my daughter.
not any Tom, Dick and Harry cannot go the prosecution inspector and get an FIR copy. Even, let me tell you, Your Lordship,
What is
in
included in Assam, I know.
in a district, prosecuting inspector called me. The FIRs after the cases are been committed to the court, the prosecuting inspector doesn't have a copy with them. They have to apply to the CGM. The CGM of Cockroach are denied in giving the FIR to the PI of that district. And why the CGM will
Not
be any?
understanding the issue. That's the problem. Though it is an important issue he's raising, but he's not understanding it. You see, these are matters we have to go by the individual facts.
Exactly. Now,
Not the
one example
Let
here.
there be an SIT, Your Lordship, let there be an SIT supervised by this honorable court. Let them, all the FIRs, all the encounters, let them be supervised by an SIT. Mountains will not fall apart. Mountains will not fall apart if there is supervised investigation. What they have to hide? If they have done, if there is no fake encounter, if they have done investigation in the proper way, then what they are shying away?
All right.
Let
all
there
right.
be investigation.
Your submissions.
Yes,
let us
now
hear.
Lordship would kindly hear my submission. My submission is that he has just uttered one thing, that one student leader was shot in Nagaon. He does not know what is the outcome thereof. The police person who shot him, he was arrested and he was behind bar for 3 months. The SP of that district was transferred out. His basic facts he does not know.
So then,
That is the problem. That's the problem.
then ask for the all the investigation.
Just shouting SIT will not do.
Mute coordinator. Mute him. He's interfering.
So that Nagaon incident, he must have gone through the concerned authorities to find out what is the outcome. The same officer, the OC of Nagaon police station, he was arrested and he was in behind the bar. Ultimately, after 3 months, this honorable court granted him bail. Government is not shying away from anything. We want the culprits should be caught.
ठीक है sir, restore को.
Number 2, in every case, we have registered FIR, paragraph 4 of that affidavit, which my learned friend was relying. May I read it, Lordship?
Yes. Affidavit dated
Affidavit, Lordship, it was on 29/9/2022. 29 September. Paragraph 4.
Yes.
May I read it, Lordship?
Yes.
In view of the above, the deponent begs to state that from May 2021 till August 2022, a total of 171 incidents had taken place, out of which 4 custodial deaths in 32 districts of Assam, and accordingly 171 separate FIRs have been registered. A statement made by him that we have not registered FIRs. Very clearly, we have stated that against 171 incident, 171 specific if it, FIRs were registered. What is the outcome of those investigation? We have to find out. Just coming to this honorable court and saying that is SIT is required, a investigation by CBI is required, that will not be sufficient. Whether these investigations done by the authorities concerned as per the PUCL guidelines, Lordship, whether we have complied, he should individually, he should examine. And if there is any flaw on our part, we are readily coming to this honorable court and say that this is the flaw. Lordship may pass appropriate order in that case. But he cannot have a universal order against 171 cases. Let the facts be completely collected by him. Whatever Lordship directs will provide, whoever comes will provide. The system is already in place. There is no requirement of any honorable court's direction to that effect.
Correct.
Everybody can go and get an FIR copy, charge sheet copy, or any material from the CGM's court, which is permissible. Now, what he will require? He will require the FIR, he will require the charge sheet or the final report under CRPC 173. Are these confidential documents? These are not confidential documents. These are available in public domain. So my humble submission is this way, the PL cannot proceed further, Lordship. Let him come and we are ready to counter whatever allegations is brought against us. The state is not shying away from anything. And we want public interest to prevail. That is my submission at this stage, Lordship. In this form, Lordship, the FPIL is not maintainable at all. In fact, may I just place his PIL first? In his PIL, he first approached the National Human Rights Commission with a letter. The National Human Rights Commission, Delhi, sent it to the State Human Rights Commission. You approach the State Human Rights Commission. The State Human Rights Commission, suo motu, registered a case also, not on the basis of his application. Both were clubbed together. The State Human Rights Commission issued notice to the Home and Political Department. We submitted a complete report. And finally, on 12th of January 2022, last year, the Honorable Court said, as there is a PIL going on before this Honorable Court, therefore, I have just procured it. Also, it is not, yes. As per section, a particular provision of the State Human Rights Commission, Regulation 7 of the State Human Rights Procedure Regulation, that matter was closed. The investigation was going on in the State Human Rights Commission, headed by a retired Chief Justice. So my humble submission is that let him come with individual facts. There may be or there may not be any flaw on our part. If there is one flaw in suppose one case, Lordship will adequately give direction. If the state is so protective, then it would not have arrested its own officer in charge and transferred the police officer in charge of the district, the SP of Nagaon. The example which he has given, I'm giving a reply to that directly. And none of the victims, family members approached this Honorable Court till now. And it is a sheer incorrect statement on the part of the PIL petitioner that there is fear in the mind of the victim's family. No. So many cases, I have gone through all the cases of Manipur and Assam for last 15 years. So many cases have come before this Honorable Court where the victims' family members approach. Assam is not run by any banana republic. It is not like that. Rule of law is prevailing in the state of Assam. Earlier, people were not out after 6 p.m. Now, Lordship, what is the situation? Lordship knows. The crime has decreased in the state of Assam for last 2 years.
So the substance of your argument, Mr.
Yes,
Saikia,
Lordship.
is that by clubbing all this together,
It will make a khichdi.
making a omnibus case, the PIL is not maintained.
Absolutely,
But
Lordship.
if the petitioner succeeds in showing specific instances
Lordship.
of,
Lordship may
any-
give him that liberty also.
then in that case, the state is willing to
Yes, Lordship.
go for a course correction,
Lordship.
take action, either on its own or
Whatever.
subject to court order. That's your,
Yes, yes, Lordship.
yes, your opinion. All right. Yes, anything you want to say, Mr.
Your Lordship, in the additional affidavit, latest additional affidavit, they have themselves admitted they have that only in 48 incidents forensic tests were done. In 40 incidents, ballistic tests were done. Ministerial inquiry was done in 92 incidents. Police inquiry was done in 122 incidents. So-called, what they claimed independent investigation was done in 75 incidents out of 171. They themselves has admitted that they have not followed the PUCL judgment in the entire 171 incidents of police firing. Now, what I'm saying in what the PUCL judgment says that married, if pursuant to the tip-off or receipt of any intelligence as above, encounter takes place and firearm is used by the police party, and as a result of death occurs, an FIR to that effect shall be registered, and the same shall be forwarded to the court under section 157 of the code without any delay. So,
1 minute, what is the citation, PUCL judgment?
it is in page 103.
What is the citation? Is it a reported judgment? PUCL is
Yes,
a
Lord, it is a
reported.
reported judgment.
It is 2014 FCC 635.
Which paragraph you are referring to?
I am referring to paragraph number 2, point number 2.
Yes.
PUCL judgment clearly states that there has to be an separate FIR. But these FIR numbers, which the respondent 1 has provided in their latest affidavit, is pertains to the FIR which has been done against the victims, the dead person. Dead person cannot come and defend themselves. There has to be 2 different FIRs. One for independent investigation, there has to be a separate and new FIR which has to be lodged against the police personnel. They provided 1 FIR number in their affidavit against 1 victim or 1 deceased person. May kindly see from page 300 and in the 345 onwards in the latest affidavit, they have given the FIR numbers against each victims. There has to be 2 FIR number. The latest affidavit of the respondent states starts from page 317, but the specific page will start from 323. The law on this is very clear, Your Lordship.
These annexures are all table of case numbers, etc.
Case number. Now, where is the FIR? Where is the content of the FIR?
Your Lordship, may kindly see.
That's why I'm saying that let him come with the FIR with a same press case.
All the FIR, these FIR are not against the police or personnel. It is very clear on the face of it.
Guesswork will not do in the court of law.
Your Lordship, may kindly see the ministerial inquiry, independent investigation, FSL report, ballistic report, all are nil. They themselves have admitted.
Nil may be, Lordship, the ballistic report may not have come. It takes time from the forensic laboratory.
Encounter took place in 2021. And it was submitted in September 2022.
So this reply that you have filed on 2/12/2022.
Yes, Your Lordship.
You have stated in paragraph 5. You're actually interfering with the court proceeding, Mr. In paragraph 5, you have said that all the FIRs have been lodged against the victims and not against the police personnel engaged in the extrajudicial killing.
Yes, Your Lordship.
Substantiate this. Where is the FIR lodged against the victim? Which is that FIR?
against the victims. Your Lordship, may kindly see my FIR, my affidavit dated March, it's in page 174, starts from page 174.
174. Yes.
I have given a compliance report in terms of the order dated 25 February. I have annexed few of the FIRs. The exact FIR starts from page 70 to 47 in that affidavit. All these FIRs has been lodged against the victim, not against the police officer. It can be seen.
And these people who are the victims, they have all died or they are alive.
So far, 56 persons have died.
And what about the
According to
people who are
the-
alive? Have they made any allegation against the police?
There are allegations even in the ministerial report, which the respondent had annexed in the first affidavit. Magistrate himself says that victims has what the victims claimed is contrary to what the police statement. The affidavit of the state dated 8 February 2022. The victims have claimed that they are fake encounters.
All right. Yes. Anything else? Anything else, Mr. Arif?
May kindly see page. May kindly see. Page 149.
Yes.
In the ministerial report, what the doctor says is that according to doctor, bullet entered from front side in the left leg and back side in the right leg. However, police shot three bullets and 2 bullets hit that victim. Accused did not fire a single shot as he did not snatch the gun. Then how can, if the accused is running away from the police personnel, how can a bullet hit from the back side, one bullet hit from the back side and one bullet from the front side of both of the legs? That is not possible. It's the ministerial report. I am not saying this.
Yes. All right. Anything else?
Lordship, my IA may be disposed of on merit.
All right. How do you You take down, heard Mr. Arif Mohammed Yasin Jwadar, who has addressed this court through remote video conference from New Delhi. Full stop. We have also heard Mr. D. Saikia, learned Advocate General Assam, assisted by Ms. P. Barua, learned counsel, appearing on behalf of the respondent numbers 1, 2, and 1, 2, and 3. First up, Mr. B. Chakravarti, learned CGC has appeared for respondent number 4. Acha. Mr. B. Chakravarti, learned counsel, has appeared for respondent number 5. Anyone for respondent number 4? Any CGC? You appeared, Mr. B. Chakravarti, for respondent numbers 4 and 5. Full stop. We have heard arguments on the question of maintainability of this public interest litigation, as well as a prayer made by the applicant in IA criminal Paper Clause 78/2022. Full stop. Order reserved.
Deeply obliged, Lordship.
Yes, we have reserved the order. We'll go through the record and see what is what. Yes. Part 2 key has anybody's. Part 2 hearing, anybody's ready?
Actually, in item number 8, I am an amicus, but I have not received the paper book. My junior check, it is there in your lordships, so we may be allowed to take it, my lord. Item number 8 and item 15, my lord, I'm also there, but 15 I'm not ready today. If your lordship allows, I'll do it on Friday, my lord. Item 15 and 47, again, I don't have the file. In item number
So you
47.
take all the paper books, whatever you
Yes,
want. And
8
then
and 47, I don't have the file. Otherwise, 15, I have the file, but anything today, I'm not prepared.
Then you go through the paper book,
Yes.
we'll do it tomorrow then,
Very well,
tomorrow Thursday.
my lord.
Party matter ready.
Number 1, 2, 3, 4, 5.
We'll rise. Let us know if somebody is ready to do it.